We're a small group right now, but I have a lot to talk about, and I just wanted to start with a little 2-minute video. So for a little bit of a time kill, I'm just going to start with this video. Well, it's 12 minutes, but I'm only playing 2 minutes of it.
I'm Gentleman Edwards. I'm very familiar with Indian child welfare. That act passed by Congress.
Well, that's probably pretty hard for all y'all to hear, so I'll just stop it there.
Click escape on the keyboard.
It's fine. I'm going to talk about mostly what he was going to say anyway, so and then I can just use this, right? All right. So the point of that little video, really in terms of trying to frame this training for you guys, is that you can't know just by looking at somebody who is Native American, who's Indian, who's ICWA eligible. So it's really important that we take this seriously in every single case. This is not just for the attorneys in Department 421. This is for every single attorney who practices independency law. And in order to understand why notice is the ICWA notice is the #1 reversed issue on appeal, we need to understand why is it so hard to get right? What makes it so difficult for us to get these notices right in these Indian Child Welfare Act cases from the very beginning? So
click it on. I think it's turned on. It's on the other side.
Technology. So just to give you a little bit of perspective, this is a photo of Carlisle Indian Industrial School, circa 1900. This is one of the Indian boarding schools where children were sent away from their families, away from their culture, away from their community, and sort of whitewashed, for lack of a better word. The mentality behind these schools and the policy was to teach the Indian away from these children. They did not let them speak their language. They took away their clothing. They took away everything essentially that made them Indian, or that was an identification of their culture, and tried to isolate them from that. As you can see, even so much in that they all have nearly identical haircuts, which I can tell you those children do not enter the school with those haircuts. That was a policy of the school, was to put them in these sort of drab uniforms with all the same haircuts and try and isolate them from their culture and community. So some of the historical trauma that will give you a better understanding for why we have such a hard time, particularly in California, in identifying who may be Native American, what children are ICWA eligible. I put a quote there that is not exactly the quote, but essentially boils down to what General Sheridan is quoted as having said: "The only good Indian is a dead Indian." The California missions in the early 18th and 19th centuries saw Spaniards taking Native Americans by force or coercion to civilize them, quote, and create labor. This Spanish influence is why it's not uncommon for you to see many Native American individuals with Spanish last names. So that's something to keep in mind. The first legislature of California authorized indentured servitude and the promise of false land. Let me just give you a couple examples of actually the laws that were in place in early California Indian law policy. Any Indian could be put into indentured servitude, And one of the reports from that time actually mentioned over 100 servants, indentured servants, 49 of whom were between the ages of 7 and 12 years old. So this was adults, children. Indian children could be kidnapped, sold, or used as indentured labor. Any Indian could be declared a vagrant upon the word of a white person and thrown into jail. And then his or her labor could be sold at auction for up to 4 months with no pay. So that, again, was a policy that ended up having a number of Indian children and individuals separated from their community, their families, placed into homes where they were forced to work and not allowed to be part of their community. There's then the government-sanctioned forced relocation and tribal termination laws, the national policies. I'm sure many of you are familiar from just grade school history or maybe high school history classes with the Trail of Tears, which was a result of the Indian Removal Act of 1830 during President Jackson's tenure. But even more recently than that, we had the House Concurrent Resolution of 1953, where more than 100 tribes were terminated. And this resulted in the withdrawal of federal aid and services and the end of a number of reservations. In fact, I believe it was approximately 70 California tribes lost their status during these tribal termination policies. So that's a big part of what we're dealing with here in California. Additionally, the Indian Relocation Act of 1956 took Indians from their land over more in the Midwest area and attempted to relocate them to more urban areas or to other states and cities where they wanted to use their labor, promised them jobs, promised them prosperity, and in fact, what ended up happening was they found themselves in these urban ghettos. Poverty was widespread. They were, again, isolated. And then the boarding schools, as I've already mentioned, where essentially they were intending to take them away from their quote-unquote savage influences, or savage lifestyle and unchristian ways. Savage is one of those terms that's very commonly, not so much these days, but in a lot of old Western films and not that old, frankly, but and even in some magazine ads is a word that is used in association with Native Americans. This is an actual magazine ad from an issue of Cosmopolitan back in 1899 that harkens back to that quote I showed you from General Sheridan. Savage rifles make bad Indians good. You know, the only good Indian is a dead Indian. That's what this is an homage to. And this was printed throughout the United States. So then we get to the actual impact in California. We have one of the largest urban Indian populations in California, here in Los Angeles. And California itself has the largest Indian population in all of the states, according to the 2010 census. Now I think it might shift a little bit with the 2020 census. However, we're up there in like the top 3 largest urban Indian populations. And that's because of those policies that I talked to you about before. A lot of Indians were relocated to Los Angeles, to San Francisco, to these urban coastal cities, also in New York. They have a pretty high urban Indian population in New York as well. We have over 360,000 individuals who identify either as American Indian or Alaskan Native, that's AI or AN alone, and additionally that same number, somewhere around that same number, in combination. Over 50% of California's Indian population traces their ancestry to tribes outside of California, again, because of this relocation and urban migration policies that were in place. In California, we have over 109 federally recognized tribes. Now, when I say here that there's 78 entities petitioning for recognition, a number of those entities are those that I referenced when I said somewhere around 70 of them were terminated through the tribal termination policies. A number of those are still petitioning to get their recognition reinstated. And some of those are tribes who are newly formed tribes who are petitioning for federal recognition. One of the handouts I've given you is the implementing, I believe it's called Implementing the Spirit of ICWA. Something about the spirit of ICWA. Yeah, following the spirit of ICWA. I gave that to you sort of because it has a lot of helpful information just in general about, oh, sorry, the phone was buzzing. About how to sort of be the benefits of providing ICWA services in general. The historical background is also noted within there, but most importantly, even if you have a client who comes in from a tribe that is not a federally recognized tribe, our Welfare and Institutions Code allows for the court to have discretion to recognize and provide services through them, with consideration of the tribe being a participant in the proceedings, through Native American legal services, and that's under WIC 306.6. So just because they're not a federally recognized tribe doesn't mean you should immediately think that, oh, we don't need to keep looking into this or provide notice to the tribe. While the Indian Child Welfare Act, the federal law, does not apply to those tribes that are not federally recognized, it's still a good idea for a number of reasons to provide notice to the tribe. Get your client's tribe involved if your client is a member of a non-federally recognized tribe. Additionally, just for your information, there are 573 federally recognized tribes nationwide. So you're not going to know who all the tribes are on this list. Nobody's going to memorize it. I have not memorized it, and I spend way too much time looking at the ICWA myself. What you should know, and for purposes of notice when we get to it, is a lot of times your clients will tell you the name of the tribe as based on its historical affiliation. They don't actually know a lot of times the federal registrar's name for the tribe. Just one example I want to give you of that is that the Pomo tribe, for instance, if someone says that they have Pomo ancestry, P-O-M-O, it will not be possible for you to go to the Federal Registrar, List of Agents for Service, and look under P to find Pomo tribes. There are more than 20 federally recognized Pomo tribes, or tribes who trace their ancestry to the Pomo tribe. Not a single one of these has their name begin with the word Pomo. And in fact, only 6 of these tribes even have the word Pomo in their name. Nonetheless, if someone says that they think they have Pomo ancestry, those notices are going to need to be sent to all, I think it's 23 affiliated tribes. Now, I do have a list and I can share it either through Jasmine or if anybody has a request, or it's also located on the BIA website. It's 73 pages, so I didn't print it for you all, but it lists the tribes alphabetically by their historical affiliation. It's a good list to cross-reference if you ever needed to check if it was a tribe you weren't familiar with. You know, the Cherokee tribe is one that's very commonly named in our cases. There are 3 bands of the Cherokee tribe that all need to be noticed in any given case unless the client knows for sure that their registration or membership, sorry, not registration, membership derives from a particular band. But with tribes that maybe you're less familiar with, like the Sioux, there's a number of different bands of Sioux, and not all of them start with Sioux. So again, if you're looking to try and check notices for your client, and you're looking alphabetically through the list on the Federal Registrar, it's not going to be the best way to address that. So I would reference the list of historical affiliation in terms of doing that. And that, again, harkens back to these removal policies and Indian tribal termination policies. A lot of tribes they originally started maybe as one band, like the Cherokee Nation, whose tribal land was originally located in the lower, in the southeast portion of the United States. And then during the Trail of Tears and other relocation policy timelines, they ended up relocating in different areas. The eastern band of Cherokee Indians relocated in North Carolina, the Cherokee Nation in Oklahoma. So that's how we end up with so many different bands whose historical affiliation still goes back to one named tribe. So that's just something to keep in mind. So really now the purpose of ICWA, that's what that judge on the screen was going to talk to you about that you couldn't really hear him at all. ICWA was passed in 1978 to establish minimal federal standards. Now why did I bold that? That's because these are minimal standards. California has actually passed a very comprehensive ICWA law scheme within our own WIC code that provides, in many cases, more protections than the federal law does provide. And the federal standards provide that where a state is more protective, those laws and statutes will trump federal policy. So it is the minimal federal standards to protect the best interests of Indian children and promote the stability and security of Indian tribes and families. As you can see there, this was because the policy review found that children, Indian children, were being adopted and placed into foster care at grossly disproportionate rates to other children. Only 2 Supreme Court cases have ever addressed this federal legislation since its passage in 1978, and both of them actually deal with voluntary relinquishments. If you have questions about their application or the details of them, I'd be happy to answer them afterwards. I'm not going to go into great detail with them right now because they are not really that applicable to our proceedings. What I do want to note is that recently ICWA has been under attack, and I actually would say less recently it's been under attack, but only just about a month ago, I'd say, was the attack successful, at least in one locale. A lot of different policy groups have been putting a lot of money into trying to take down the Indian Child Welfare Act since, at least I'd say probably the last 10 years or so. One of those being the Goldwater Institute, which, interestingly enough, fun little fact, Goldwater actually voted for the passage of the ICWA, so this institute in his name is probably not doing work that he would have approved of, but nonetheless, in this Bracken v. Zinke case, in the U.S. District Court for the Northern District of Texas, has declared that ICWA and its implementing federal regulations are unconstitutional. That's really scary when you read it right there on the screen, but let me just tell you, for our purposes, ICWA is still fully applicable, 100% constitutional, though you may be faced in a case, if you end up with an ICWA case, you may be faced with foster parents, de facto parents, outside legal counsel coming in and really trying to put money in making this happen in more places across the United States. Just so you know, the bases for the declaration of its unconstitutionality were, number 1, the 14th Amendment Equal Protection Clause. This court found it to be an impermissible racial-based classification. Does anybody have an idea as to what problem may have existed with that rationale?
That it's a political
based classification, yes. I'll help you out since you're eating.
right.
Very good. This ICWA, it's a commonly misunderstood idea about ICWA, is that ICWA is a racial-based classification. In fact, it would be my position that this should not have even been decided under strict scrutiny, racial-based classification. It should have been decided under rational basis, political-based classification. And as you'll see later when I get into what the definition of an Indian child is, it becomes clear in the statute that this is based on political affiliation, on membership and citizenship in a tribe, not simply heritage or ancestry or race. So it's important, if that ever becomes something that de facto parents or those are trying to raise, make sure that your court understands this is not about race. Indian nations are sovereign nations. We're dealing with independent political entities here, and they're members and citizens. And then the other two bases were the 10th Amendment anti-commandeering and clause and the Commerce Clause, which I won't get into a con law discussion with you guys over that, but just for your information. I will have you know that the due process requirements and protections created by the ICWA have in fact been touted by a number of child welfare agents, advocacy groups, including the Casey family programs, who put lots of money into child welfare advocacy as the gold standard for child welfare decisions for all children. And this is because a lot of the things that ICWA is trying to protect are frankly things that we should be concerned about for all children who come through the dependency court system. You know, there's a high burden and preference on showing that placement should occur outside of a relative's home. Well, that's something that I think that we would, well, we have a relative placement preference in dependency cases. It doesn't provide quite the same protections as it does in Indian Child Welfare Act cases. Additionally, it puts a high emphasis on maintaining a child's cultural identity and connection to their community and familial ties. That's also something that we should want to encourage and be mindful of in any dependency court case that comes before this court. So, is this really still a problem 40 years later? I mean, I know kids were being removed because they were Indian at grossly disproportionate rates 40 years ago, but do we still have this issue? Absolutely. Just 3 years ago, wow, math, ACLU filed a suit. It was in South Dakota, which, fair, probably not quite the same here in California, but still a problem throughout the United States. And they won this suit. It was found that 36 years later, children were still 11 times more likely to be removed from their families and placed in foster care than Indian children. So this is not something that has cured itself or no longer needs our attention or protection. This is just another reminder of sort of the purpose of the video that I showed you at the beginning, and for those of you who weren't here to see the video, there is no look of an Indian. And this is also a reminder of the continual, I'd say, offensive imagery and characterizations of Native Americans in our popular culture. I mean, the fact that the Redskins is still an appropriate name for a football team, could anyone imagine us calling a team the Blackskins or the Brownskins? That would not in any way, shape, or form be something that people were fighting, I think, to, well, it would not, with reasonable minds, would not believe that that's appropriate. This cartoonish image of the Cleveland Indians. You know, even our own president sort of mocking somebody who says that they have Native American ancestry by calling them Pocahontas in reference to the Disney character. These are things that are still a problem, and we do need to continue to create awareness and try to address them. So now to the law, because I'm sure you all are tired of the history lesson. But what is an Indian child? So an Indian child is an unmarried person under 18 years of age who is either, number one, a member of a federally recognized tribe, or eligible for membership in a tribe and the biological child of a tribal member. Okay, so when I was talking to you earlier about this being a political classification and not a racial classification, it's because it requires that membership or citizenship. Or they need to be the child of a member or citizen, i.e. they're inheriting that sort of citizenship or membership potentially. In re LADL-LA was a Supreme Court case out of our California Supreme Court that in fact invalidated parts of a rule of court that required application of the ICWA where a child was only eligible and the parents were not members. I'd say appropriately so, because that would have been applying the Indian Child Welfare Act in a case where it was purely based on, it wasn't based on a membership or political affiliation at that point. It was just based on an eligibility. So just that the child is ICWA eligible does not give rise to the ICWA applying at that point. Once you've determined that a child is ICWA eligible, if the parents are not a member, if the child is not a member, there need to be steps taken to get that child membership or citizenship within the tribe, or to have your client, if your client is the Indian parent, have your client secure membership or citizenship within that tribe so as to secure the application of the act to the case. Does that make sense? Okay. I already told you that there's a list of federally recognized tribes that you can reference. I gave you the website link for it, and I'm happy to shoot that out by email to anybody who requests it as well. Importantly, in DBV Superior Court, this is sort of a nuance in language that I think people get confused a lot of times with. Membership does not necessarily mean enrollment. So we talk all the time, maybe the words membership, citizenship, enrollment get sort of talked about intermixed, and nobody makes a distinction. DBV Superior Court talked about this, and now the new law that's going to be going into effect January 1st of next year under 224.2H also confirms this. The tribe must confirm in writing that enrollment is a prerequisite for membership. So how many of you have had that case where you got, ICWA notice was required, the notices were sent out, you got a response back from the tribe that said, our records show this child, our records reflect that this child is not an enrolled member, period. Has anybody ever had that? Okay, that is not sufficient to say ICWA does not apply. That tribe needs to, in that letter, also say, this child is not an enrolled member, and enrollment is a prerequisite for our membership or citizenship requirements. So if you get that, then more inquiry or notification needs to be done with that tribe in that case. Sometimes you will get the case where it does in fact say, our records do not reflect that this child is defined as an Indian child under the Act, as this child does not qualify for membership or citizenship within our tribe. That would be sufficient. But enrollment does not equal membership, and that's one of the things that I cannot stress enough because people don't understand it. They think they're the same thing. Just a little note here. Haven't heard this brought up really as much as it used to be for a while, the existing Indian family doctrine. Are you shaking your head because you have?
No, I'm...
Okay, okay, good. It hasn't been brought up as much lately, I think because California really jumped ahead of the trend with our Senate Bill 678 a couple of years ago, and now Welfare and Institutions Code 224A2 and C, and now the federal rule makes this very clear that you can't deny the application of ICWA because this child doesn't have the experience of an Indian family. They weren't raised with the culture. Their family doesn't attend powwows. They're just a baby. They don't even know what it means to be Indian. It doesn't matter. If the child meets the definition of an Indian child, ICWA applies, period. Okay? It doesn't matter whether the parent ever had custody of the child. It doesn't matter what the child's blood quantum is. You'll hear a lot of times in the news reference to blood quantum. Not every tribe, and in fact, I would venture to say a lot of tribes do not use blood quantum as their requirements for membership or enrollment. Sometimes it's just through lineal ancestry. If you can prove a lineal ancestor, they will allow membership or citizenship. There are certain tribes whose enrollment requirements or membership requirements do in fact list blood quantum as a prerequisite for eligibility, but that is up to the tribe to determine. So you cannot look at any one child and say, oh, well, your Indian ancestor was 4 generations back. That doesn't seem like a strong enough connection or a strong enough blood quantum there for me. That's completely irrelevant. So when you see that mentioned, it shouldn't even be a part of the conversation unless the tribe has said that that's their requirement. Yes?
So what should you do if when you're filling out the ICWA 020, your client says, well, yes, I have Indian ancestry, but it's not enough blood quantum?
Keep asking questions.
Yeah, I'm going to come back to that question when I get to the ICWA 020 because I really like that question. And I have a lot of pointers for what you should do when your client is giving you a number of sort of difficult answers to your questions about their Indian ancestry. So just really briefly so that you have an idea of what we're looking at here, this is the new legislation highlights. I'm only going to be talking today about inquiry and notice. If you would like to join me for part 2 in December, I will be going into depth about how our continuance statute is changing in terms of Indian children, timelines change, active efforts, there are specific findings required for detention. Again, every case that you guys have, if it's a possible ICWA case, this is not just Department 421. Ex parte request prior to disposition, and qualified expert witnesses. When does ICWA apply? Only to proceedings where it is an Indian child and at issue is one of the following outcomes: foster care placement, termination of parental rights, pre-adoptive placement, or adoptive placement. So what that's going to mean is that's going to be, ICWA notice is going to be applicable to any of your jurisdiction and disposition hearings, a 2-6 hearing, a review hearing where the recommendation is to terminate reunification services and set a 2-6, and that's pretty much it. So, does it apply to all Welfare and Institutions Code 300 proceedings? All juris and dispos? No, it does not. In fact, notice is not required where foster care is not recommended. So it's important to pay attention to what the recommendation is in a case. If a child's placed home with one or both parents, even if it's not the Indian parent, the courts have said that notice is not required. Does that mean you guys shouldn't still ask for notice to be done? Does anybody have a guess as to what my answer will be to that?
No.
You should still push that notice at least be done to advise the tribes. Is it going to mean that the ICWA, that it's going to hold back a case or that the higher burdens of proof are going to apply? No. But how many of us have seen a case that started out home of parents and then ended up foster care? It's best if you can get the tribe involved and notified as early on as possible. So even if it's a possible ICWA case and the recommendation is home of parents, I would still ask that the notices be done, and maybe that's the case where a progress hearing for notice is appropriate, but not in a case where the recommendation is actually for suitable placement or otherwise. In Re KL just recently came out, 2018 case, I don't even have a site for it yet, really just reaffirms this. The provisions of ICWA do not apply to a case where the agency has placed a previously non-custodial parent, and I gave you some of the reasoning therein. I included Jennifer A. as the example of what I've just said to you, that even if the court places ultimately at the disposition as a result of a contest, what you're concerned about is the recommendation. If the recommendation is foster care, ICWA does apply. So, now on to Ms. Brewer's question. Now we know some of the background for Indian Child Welfare Act notices and inquiry proceedings. It's required in every Indian child custody proceeding as previously defined. You'll see it first mentioned with the 010 that DCFS files with the petition, and that it's our obligation to notify the court when every parent makes their first appearance and fills out an ICWA 020. We really need to do this. I'm finding in a lot of Court of Appeal cases, they're not finding one in the record. Maybe it's for these late appearing parents who think that it doesn't need to be done. I think our policy is always to do it, keep doing that. But what do we need to include on there? And just note, this includes legal guardians and adoptive parents. I know I did say that an Indian child is defined as the a member or eligible for membership and the child of a biological and the biological child of a parent who's a member, but CA has said, oh sorry, DC has said that this applies even when the child has no biological ancestry in the case of an adoptive parent. So just because they're an adoptive parent, some tribal enrollment or membership requirements allow for adoption into their tribal community. But CA says Not triggered where it's a presumed father who's neither biological or an adoptive father. They did not extend it to, so if you have your 7611D father who comes in, he is not biological, but he's a presumed father of this child because of 7611D, and he says, I am I'm a registered member of the Cherokee Nation. This case says that notice is not triggered. That even if, I mean, which just seems absurd to me because we don't know if the tribe would have allowed a child to be a member of their tribe by nature of a legal parental relationship, but unfortunately, the ICWA does not recognize legal parental relationships. What it's really trying to protect is biological or adoption is the only extension of the law. So just note that. Now as to what you fill out on the 020.
Can I ask a quick question?
Yeah.
Why legal guardian?
Why I say legal guardians is because the form itself has a box for legal guardian, and the legal guardian many times are family members or individuals close to the child, and they're supposed to give the court information, their own Indian heritage or ancestry, to the extent they're not part of the actual biological family, is probably not relevant, but any knowledge that they may have as to the child's ICWA eligibility. What you're really supposed to be filling out on that form is the court's determining if this child is an Indian child. Sometimes that's determined by your client's Indian heritage, but sometimes that's just determined by people's knowledge of the child's Indian heritage. So they have asked that form to be filled out by legal guardians as well to indicate whether they know if the child has any Native American ancestry based on their relationship with them. Yeah, no problem. Thank you for clarifying. So to the question about what do we do on the ICWA 020. Client says, I guess did they name a tribe? Sure. Okay, they say I'm Cherokee, but I don't think I have enough blood quantum, it doesn't matter. My advice to them is that's not, we still have to provide the information to the court, we still have to provide the information on the form, and that's for the tribe, it's for the tribe to have notice and to make the determination. Their requirements may not necessitate a particular blood quantum. If the parent says, well actually I've looked into it and it's still not, I'm sure, I've researched it. Doesn't matter. Enrollment, membership, citizenship requirements can change. A lot of tribes are continually amending their requirements, so it doesn't matter if your client thinks or says, I'm not going to be able to be an Indian, my child's not going to be defined as an Indian child. If they believe that there is an indication or a suggestion that this child may be an Indian child, the notices are in fact still required. And what you should do is get as much information as possible. Please don't just check the box on those forms, you guys. What we found in a lot of these Court of Appeal cases is you can protect your client on appeal when you're putting on that form. If they say to you, I have Cherokee ancestry, I don't know, somebody told me a really long time ago that we might have Cherokee ancestry. Okay, well, who told you that? Well, my grandma. Okay, is your grandma still living? Yes. Do you have contact information for her? Okay. What if your grandma's not still living? Okay, well, is it your mom's mom or your dad's mom? Is your mom or dad still living? Do they have contact information? Would they know more about your Indian heritage? Is there a historian in your family? Is there some person within your family who knows more about this? Any person who you can name and provide contact information for on that form is going to help in determining whether a child's eligible and in protecting your client's rights on appeal if this becomes an issue. Okay?
Jessica, I think it's also, I mean, you know, in terms of detailed questions, to ask where your family is from.
Yes.
And are they still there? And do you know, I mean, there are people who have those records in their old family Bibles. And is there anybody in your family who's got a degree of Indian blood card? Does anybody have a card? So just there are little things that you can ask that might trigger a little bit of information.
Very much so. Has anybody in your family ever lived on a reservation? Definitely. There's a lot of questions, as Kathy points out, that you can really do to try and help trigger your client's memory and get more information. And to the point of a client who maybe says, well, I don't want to deal with that, it's fine, just don't put it down there because like I hear it's going to delay the proceedings and I just want to get this over with. Well, here's the problem. WIC 224.3E says that any person is subject to court sanctions if they knowingly or willfully falsify or conceal a material fact or counsel a party to do so as to any information that a child may be an Indian child. So we as attorneys cannot be telling our client then, okay, it's fine, then we won't let the court know. You need to say to them, look, I understand that you think that this might be a delay in the proceedings, but we need to give this information to the court. It's required by law. It is a sanctionable offense if we do not, and this could hurt your case. I mean, it could hurt their case down the road if they misled or concealed information. And just so you know, although I say it should be on us to really fill this out as much as possible, the duty is on the court and DCFS, and it's an affirmative and continuing duty. It does not stop, it is ongoing, and it is not really our job, but we should do what we can to help protect our clients and get the information out there. So, inquiry giving rise to reason to know. Now, I'm going to talk about inquiry in a couple different ways. There's the initial inquiry that gives rise to reason to know, which may trigger notice. And then once notice is triggered, there's a further inquiry to fill out those notices. So I know it can get confusing when you hear me say inquiry, then notice, then inquiry again, but that's really what I'm talking about when I talk about a couple of different versions of inquiry. So I've given you all the reasons there that there may be reason to know a child is an Indian child. And what is important to know is that both the Code of Federal Regulations and now our new code, section 224.2I1, is going to say that you must treat a child as an Indian child unless it's determined otherwise. So the moment that you have reason to know a child is an Indian child, they need to start providing, if it's triggered notice, they need to start providing ICWA notices. They need to make active efforts determinations. All these provisions that would be triggered if the child were determined to be an Indian child apply until the court says, no, this child is not an Indian child.
And then when is the case transferred to 421?
So by local rule of court, we have a local rule of court 7.10, I believe, that provides that upon the affirmative indication that a child is an Indian child, the case shall be transferred to the designated Indian ICWA courtroom by agreement of the supervising judge. So it doesn't happen until the tribes respond back indicating that yes, this child is an Indian child, but immediately upon that determination, you can request pursuant to the local rule that the court, it's supposed to be mandatory unless the supervising judge does not agree with it. You can ask that the court transfer this to the Indian Child Welfare Act designated courtroom, provided that you're okay with Padilla hearing that case. So, inquiry may trigger notice. When does inquiry trigger notice? It doesn't really take that much to trigger the actual sending out of the notices, okay? So, Dwayne P. is one of the seminal cases on this that says that notice is triggered by a suggestion that the child is an Indian child. And then they gave you the, I believe it was the Webster Dictionary, synonyms for the term suggest, which are imply, hint, intimate, insinuate. Doesn't take much. What you see from other cases is that, like in Ray Jonah Dean, where it says information that is vague, attenuated, and speculative will not trigger notice. In that case, the person said, well, I was told by my grandma that I had some Indian ancestry, but it's like way back, she's dead, I don't really know anything more about it, I don't know what tribe, I just know that like they talked about me maybe having Indian ancestry. That was not enough. However, what you see in these other cases is that usually if a parent can assert the name of a tribe, that's going to be enough right then and there to trigger the notice. Dwayne P., father asserted Cherokee. Alice M., they were able to name Navajo Apache, and Cadence P., which was a reversal out of, I believe, Blackshaw's court. The juvenile court improperly found that the Blackfeet claim was insufficiently supported and the Creek and Seminole ancestry was too remote. She tried to say, well, it seems too far removed for me because it was through an uncle. The Blackfeet claim, the parent named it but couldn't find any relative to really support that claim. But that doesn't matter. Once the parent says that they have that claim and they think it's there, that should be enough to trigger the notice. The tribe will make the determination if that child is an Indian child or not. And just a reminder again, this is another 2018 case. We have had like 6 this year on ICWA alone, maybe even more. Once there's sufficient information to believe that the children might be Indian children, the responsibility for compliance falls squarely and affirmatively on both the social services agency, so DCFS, and the court. Hold them accountable, you guys. So, the duty to investigate, that's the further inquiry once notice is triggered. So that's going to be, you guys all have a copy of the ICWA 030 form? Yes? Okay. So the ICWA 030 form is the notice that must be sent out with those, once notice is triggered. And the duty to investigate is to investigate and determine all that relevant information that should be filled out in that 030 form. So again, I think these are all 2018, right? Yeah, 3 2018 cases. 2 in just the last month or so I don't have citations. And Elizabeth M. out of Zeidler's court, indicating that the department has this affirmative obligation to investigate information. They must interview living family members who may have information, or others who may have information. Again, we make their job a little bit easier for them and help to speed things along, because sometimes it's not in your client's best interest for a case to be delayed for these notices. If it is, that's your call. You make the decision on what's in your client's best interest. But it helps us to help them by providing them with the contact information for these living family members who might have information. Nonetheless, whether or not our client does so, the department has an obligation to do so. So if you see in a report that your client named that they have Indian ancestry, Cherokee, and then they say, my mom might know more information, or even if they don't say it, they just say it's through my mom. Let's just say that. They say it's through my mom. They don't say that mom's going to have more information or anything like that. And then you see that the department has spoken with the maternal grandmother to obtain her statement as to the allegations in the case, right? They've gotten a damning statement from maternal grandmother about how mom's a drug user and has mental health issues. But did they ever inquire further about her Indian ancestry? They fill out the ICWA 030 and they write unknown or not applicable for half the information in there. If you notice that maternal grandmother is named in the report and they didn't include her name in those 030 notices, and they don't have a current address for her, a date of birth for her, a place of birth for her, and she's been in communication with them, that should be pinging red flags like crazy for you to object to those notices, because that is not complete. The department needed to actually follow up with her and fill out the information accurately in that form. Additionally, in NG, they determined that they need to, it's again a continuing and affirmative duty. So they had a duty to fully investigate the paternal lineal ancestry in that case and provide complete and accurate notices to all tribes identified. What happened here was the parent originally indicated, I want to say I think it was Sioux originally. They started getting all the information for that. Then some relative that they started interviewing mentioned Cherokee, somewhat offhand. They only sent the notices out to the Sioux tribes. They need to also send those notices out to the Cherokee tribes, because at that point that information that was obtained through this investigation gave them reason to know maybe there might be some Cherokee ancestry here as well. And then this case is rather funny, I thought, because what we find here is that typos are not excused, okay? So the fact that they wrote on this case, I think they misspoke spelled the maternal grandfather's last name, and he was one of the lineal ancestors. They wrote maternal great-great-grandfather instead of maternal great-grandfather for one of the individuals, just mistakenly. That was not excused. Those notices need to be complete and accurate, because that is the only way a tribe can actually look back to their historical, sometimes their historical roles of membership to determine if somebody was named on them, and thus gives rise to membership or citizenship for the child. So, I already told you, if notice is required, what are you going to do? Check for it. Kind of went through this in terms of checking the 030. I mentioned already that this issue here is tribal sovereignty. The determination by the tribe is conclusive, and they can change their membership policies at any time. Just so you all know, so that you can take a big, deep breath and sigh of relief, Isaiah W., which remains good law and was a California Supreme Court case, says that this issue is not waived by a parent if, it's not appealed at disposition. The appeal comes at a 2-6 hearing. It can still be raised at any time, because the issue we're dealing with here is the tribe's right to intervene and participate and know their tribal sovereignty. And it's designed to protect the tribes and the children, notwithstanding parental inaction. So we're not concerned about a parent saying, oh, I'm just going to waive the notice. A parent can't waive ICWA notice. You can go ahead and do that if it benefits your case to try and go forward, but it's not going to waive it moving down the road if an appeal comes up later. The ICWA 030 224.3 is now going to say what it shall include. It's to be completed by DCFS or the party seeking placement, just so you know. So if somebody else petitioned for removal, then say it was a 388 petition by Minors Council to remove from your client, then Minors Council is actually responsible for the 030s. Must be sent to the parent, custodian, and all tribes that are required. Please refer to the federal registrar for the addresses, the current addresses that it should be sent to. They get those wrong all the time, and if it doesn't go to their designated agent, a lot of times then the tribe isn't actually getting the information timely, and that's why you might not receive these responses back in a timely manner. Notice timelines of proceedings shall not be held until at least 10 days after the parent and tribe receive notice of the hearing. So that's receipt of notice. No hearing shall proceed. No Indian child custody proceeding, that is. So your jurisdictional hearing should not go forward until at least 10 days after the receipt of the notices by all tribes who are required to receive notice. That is a valid basis for a continuance if you need one. Also a basis for a continuance if you need one is 224.3D. That is a mandatory continuance of up to 20 days to prepare for the proceeding if you need to. So just note in these cases where you may have Indian Child Welfare Act applicability, it does provide you with some tools if you are in need of an extra time and your court is pressing you and saying, no, you have to go forward today, you have to go forward today. You do have a basis for continuance requests.
Jessica, what would you do if you have the dilemma of a case you feel should go to no time waiver trial, but you have a native parent?
What I would deal with, well, I would probably first of all explain to I probably would need more facts concerning that case. If I thought that I had a very good no time waiver and the indication or tentative or feelings I had was that this case was going to be dismissed or the child was going to be placed home with my client, and they absolutely did not want to wait. I explained to them all the potential benefits in terms of the higher burdens of proof for ICWA cases. I explained to them the active efforts requirement. I explained to them those issues. And they don't want to allow the tribe, if this child may be an Indian child, to potentially intervene. Like I said, you can't waive it. So, I mean, if it's in your client's best interest and that's what they're asking to do, I think that you could not raise the issue if it was something that I know you're making a face at me, but you have to do what the client wants. I mean, I don't think it's ever a good idea, but I would counsel the client out of it because I really don't think that it ever is a good idea. And frankly, like I said, the applicability of the Indian Child Welfare Act applies until they determine not. So you could ask to go forward
and
apply the standards, but you're going to probably at that point get pushback from county council who's going to say, no, we want a continuance, these notices need to be done. So, I mean, unfortunately, there is just that dilemma of no time waivers and Indian Child Welfare Act notices. What I would suggest is flagging that issue at detention. You need to flag that issue at detention, and maybe you should ask your court to set the 10-day requirement. A no time waiver trial, if they're detained, is 15 court days. There's plenty of time within that for the 10-day requirement if they get on it and get those notices sent out. I might ask for a progress for the department to show proof of sending out the notices if you're really concerned about trying to push it forward on a no-time waiver. Just a thought. Really quickly, last little bit here before a final slide about remembering some cultural concepts. This is pretty important change, and I probably will get a little bit more into this in part 2 as well. But this is how timelines change a little bit. Right now, the law says that if 60 days have passed after the notices have sent out and you haven't received any substantive responses, then the court can just say, okay, it's not an Indian child. That goes away. There's no more 60-day requirement that says that's our threshold for determining if a child's an Indian child or not. What it now says is that once it is suggested, the court cannot make a determination otherwise until they determine on the record, after review of due diligence, copies of notice, return receipts, and tribal responses, that there is no reason to know that the child may be a member or eligible for membership. So what this means is that the department is going to have to actually be doing more work here, more legwork. If they're not getting the responses back from the tribe, you need to reach out by phone, email to the tribal representatives. Try and get them on the phone. You can do this too. If it benefits your client, you can reach out to these tribal representatives and try and assist in getting this information to the court in a timely manner. But basically, it completely does away with the 60-day timeline. So the courts can make the determination as soon as they have the declaration of due diligence that either all the notices have been sent out and responses have been received, or where a response has not been received, that the department has done their job to speak with someone. Sort of think of it like a UCCJA case. They need to actually make that email, make that phone call, give them the opportunity to say we want jurisdiction or not. It's kind of similar to that concept. And then if any subsequent information is received, then there's this continuing duty. So new notices will need to be sent out if your client all of a sudden halfway through a case decides, oh, actually I got an Ancestry.com account and I started looking into my background and I found all this new stuff and these pictures and my relatives' names and information. That's going to trigger new notices, new ICWA notices. Unless there was a failure early on, it's not going to reverse the findings. It's just going to trigger new notices and moving forward treat it that way. If there was a failure originally, then they're going to have to reverse the findings and vacate the proceedings and start anew. It was a lot of information, but this is just for you guys to remember some cultural concepts to remember. I'll let you read them on your own. This is from the Smithsonian National Museum of the American Indian Education Office, but it keeps you guys updated and informed about what we're dealing with. And then there's just some helpful links for you all. So.